Hi everyone, it's Mark and Matt from Chartergates, and in this video we're going to be looking at the joint and several liability umbrella reforms with a particular look on how they affect the self-employed.
There are three things that I want to cover in a bit of detail today.
Okay.
There are three main ways that we think this new legislation's really going to affect the self-employed market. Yeah. There's an overlap between them as well. We'll go over in enough detail for people to understand, but we have got more videos on the detail of how these three particular situations work. But let's start off with the traditional umbrella employment scenario. If you're using an intermediary to engage self-employed individuals, it's perfectly possible, just like any other situation, the revenue might decide they think they're employees.
Yeah.
So this is what you might think of as an inadvertent umbrella company.
Okay.
Not the same as a purported umbrella company, which we'll talk about separately, but you inadvertently think you've got self-employed people, but you actually got employees. So this is just the revenue saying, we think you've got status wrong.
Okay, so the classic, we're trying to recategorise the self-employed. Okay.
Still a risk in the self-employed market, particularly in construction, happens all the time. Employment tribunals, and we've talked in other videos about the Fair Work Agency and how that might be ramped up from April this year, how that could affect the way this game's played. So still a risk for clients and for agencies. If it turns out that the workers are employed instead of self-employed, that just creates an umbrella company situation.
Okay.
And in that situation, if it's direct to client, the client's going to be liable for the PAYE liabilities.
Yeah.
And if there's an agency involved, the agency and the intermediary are going to be jointly and severally liable. So it could be client and intermediary, could be agency and intermediary, both liable for PAYE from April.
Okay.
If the revenue recategorise individuals as employed.
Okay, so situation now, HMRC come out and recategorise successfully individuals engaged by an intermediary on self-employed basis as employees.
Yeah.
Right now, the liability will sit with the intermediary.
Correct.
But from April, what you're saying is, under this new legislation, if HMRC can successfully recategorise these self-employed individuals as employees, the liability is shared with the intermediary and the end client.
Exactly right.
Okay.
And I think the difference is with a traditional umbrella company, PAYE is being operated. So there are deductions, there are payments over to HMRC. There's still joint and several liability, but it's only going to be a situation where the umbrella folds for whatever reason, or there's some sort of technical error. Most of the liability is probably going to have been paid over to HMRC during the course of the business between the client and the umbrella company, agency and umbrella company, as the case may be. In a case of recategorisation, I mean, if it's construction, CIS is going to be deducted, but if it's just self-employment and no deductions, the liabilities, nothing's going to have been paid over.
Yeah.
And then suddenly there's a huge liability. It's on the intermediary, unless the intermediary is holding a massive amount of money ready to pay it over to HMRC. It's probably going to end up coming back to the client or to the agency. So big risk potentially.
And that'll include employer's NI?
That'll include employer's NI. We've done some rough calculations. For a worker on £50,000 a year, there's about £17,000 of liability. So that's per worker, per year, times however many years. And the revenue can go back 4 years, 6 years with neglect, 20 years with fraud.
Okay.
Obviously, this only starts from April, but the clock is ticking. Yeah. And then obviously they'll add interest to that as well. So the clock is ticking from April, and the liabilities are stacking up pretty quickly.
Yeah. Okay, so that's the inadvertent umbrella company.
The inadvertent umbrella company.
How else does this affect the self-employed?
Another way, and probably a more likely scenario, a more likely route of attack for HMRC. And by the way, these things overlap, and HMRC can pick and choose between them. They could even pick all three and argue all of them in an alternative. But we think the main line of attack from HMRC will be a case one umbrella situation. If they're going to recategorise people as PAYE.
Purported umbrella?
This is a purported umbrella
So case one, purported umbrella company rules. Okay.
If you want to dig into the detail of that, obviously we've got a separate video talking about purported umbrellas and how these different cases work. It is quite complicated. It is quite nuanced, but the theme really is it's a sort of impression of employment test. So
Okay.
if
That seems
anybody,
wide.
it is very wide,
Yeah.
wide ranging. If anybody at the client or the agency thinks that the worker's an employee, they are an employee. Or if the umbrella company does anything to suggest the worker's an employee, they are an employee. So it's a kind of I think, therefore I am, or the revenue thinks, therefore you are situation here. So all we've got to have is a contract clause, piece of documentation, some representation from the umbrella, something suggesting there's an employment, people not having a good handle on how people are actually engaged.
Yeah.
Then we've got this purported umbrella company situation. And that converts everything to PAYE, same as we were discussing a minute ago. It creates a liability out of thin air.
But so no status test.
No status test at all now. No, this is
Okay.
where individuals aren't employed, they're self-employed,
Yeah.
but somebody thinks they're employed,
Okay.
or the umbrella has done something to suggest they're employed, provided some piece of evidence that's intended to suggest they're employed. So it could even be an email saying, yep, they're all employed, or they're PAYE. I mean, it's not quite saying they're employed, but that happens a lot, and it's a piece of evidence.
But I suppose it goes towards creating the impression.
Absolutely, yeah, it's a piece of evidence that they're employed, and definitely something the revenue could to hang their hat on. So if we just dig into the detail of this test for a moment, it is complicated. We have got a video with much more detail on it, but the basic theme is all the revenue need to say is that they reasonably suppose somebody would assume the worker's an employee. So it's a sort of double-barreled, very wide test with a pretty low bar, we think. Obviously, case law will develop how this works in practice, but the wording of the test, I think, sets a very low bar for HMRC to just come along and find a piece of evidence and say, well, it looks like they're employees, or you should have supposed that they were going to be employees. And that's why we're calling it this impression test.
Yeah.
And that's enough to convert self-employed people to PAYE, and then all the liabilities arise, as we've been discussing. So yeah, it's quite a concern, this one.
Yeah. And I suppose there's the other element of case one where someone takes steps to give the impression to someone that they're employed.
Yes, yeah, any piece of evidence intended to do that, whether it has that effect or not. So providing a copy of a payslip when someone's self-employed, saying in an email they're going to be PAYE, even could be inadvertent, mistaken, sloppy.
Yeah.
But if the revenue think, again, it's the test is in the revenue's hands. If they think this was the intended effect of what you were doing, and whether it had that effect or not, that's enough for them to mount an argument that everyone should be PAYE. The intermediary becomes liable, the agency becomes liable. And the scary thing about this particular purported umbrella situation is it could be things happening at the client end, on the umbrella end, that are creating liabilities for the agency in the middle. So this is going to be a big concern for the agencies.
Absolutely. Okay, so we've got the inadvertent umbrella. We've got case one purported umbrella.
Yeah.
You said there were three things. So what's number three?
Number three on our hit list, and this is specifically targeted for the self-employed sector, quite clear from the way this legislation is worded. So this is where you have a scenario where you've got an end client and an intermediary company supplying self-employed labour directly into the end client, liable for the Section 44 test, the supervision, direction and control test.
Okay.
At the moment, everybody's self-employed. They're running the test, they're happy there's no SDC, and everybody's happy. However, from April, the client is going to be jointly and severally liable for any PAYE if that SDC test fails. So if anything goes wrong, if the intermediary can't demonstrate that there's no supervision, direction or control over the manner of the work, and no right of it anywhere, then not only is that intermediary liable for Section 44, the client is also now going to be jointly and severally liable as well. So they have a massive stake in making sure that SDC test is passed and done properly, which is maybe not a bad thing. There is one exception to this, and that's the situation where that intermediary supplying into the client is an agency that found the client for that particular worker.
Okay, so
that takes
work
them outside
finding
as well.
services.
Work finding services,
Okay.
traditional agency, but they have to have provided it in relation to that client for that worker. So it's quite narrow and specific, but it's probably going to rule out most situations where you just go to an agency and get a self-employed person. So clearly, deliberately targeted at the self-employed intermediary market, supplying directly to clients.
Yeah.
No doubt about that whatsoever. We think there'll still be quite a benefit for clients to use self-employed intermediaries in terms of ring fencing, employment liabilities, back office support, administration, etc. But what won't happen from April is you can't just pass over a self-employed cohort of workers to an intermediary and say, there you go, your problem, I've no liability for tax and NIC now. You're still very much on the hook as the client.
Okay, so it sounds to me from the three different scenarios you've mentioned that a lot of them require clarity and communication within the supply chain.
Yeah,
particularly with regards to case one, I suppose, where everyone needs to be on all fours in terms of how the individuals are engaged and how they communicate with each other on how the individuals are engaged. So a lot more work maybe for end clients to do in how they go about engaging self-employed individuals via an intermediary.
Absolutely, yeah. And I'll say this again, these things, they're not mutually exclusive.
Yeah.
They overlap all the existing risks of Section 44 employment, etc., etc. Getting the contractual chain wrong or the integrity of it wrong, the right contracts not being in the right place between parties, it happens quite commonly. Yeah. You need to understand exactly how people are engaged, who they're engaged by, have the right contracts in place. Everybody in that supply chain needs to know how people are engaged, and contracts, documentation, all the ancillary documentation around how people are working all needs to be consistent and facing in the right direction. Because one of these three risks will rear its ugly head if that doesn't happen.
Okay. Well, thanks, Matt. I think that's been really helpful, because one of the things I know some of my clients have been told by intermediaries is, don't worry about the legislation. It doesn't affect us because everyone's self-employed. So I think it's really important that you've shown that there are at least three ways in which this legislation can apply to self-employed engagements, and they might all apply as well in any given scenario.
Absolutely. I mean, it's not all doom, gloom and disaster. I mean, it's just a case of making sure the due diligence is done, making sure the right terms and documentation are in place. But to miss these risks and not have the right procedures in place, I think it's going to be very dangerous from April.
Absolutely. Well, thanks again.